Hello everyone, welcome to Drishti IAS. You're watching the NCERT Foundation Series wherein we study the subject of political science or polity with the help of MCQs and PYQs wherever relevant. So without further ado, let's plunge right in. As usual, I have brought to you a quick glimpse into what we are going to be covering today with the help of questions, and I have brought for you chapter 2nd of your class 11 NCERT. The chapter is called Rights in the Indian Constitution, and here we'll be talking about the importance of rights, the Bill of Rights, the fundamental rights in the Indian Constitution, DPSPs or the Directive Principles of State Policy, relationship between fundamental rights and DPSPs, and there is a brief mention of fundamental duties as well. So this about sums up your chapter for today. Let's begin with the previous day question. Which of the following reflects the principle of checks and balances in the Indian Constitution? Now, if we talk and when we talk about principles of checks and balances, we are basically talking about the fact that one organ of the Indian Constitution or one organ of the Constitution should not become overpowering over other organs. That is the whole point of checks and balances. Basically, it can be considered as an extension to the separation of powers. But of course, in India, we do not follow or we do not admit a strict separation of powers as in the US, but rather there is a functional overlap at times, but with checks and balances so that one organ of the state does not become more powerful and all-consuming. So which of these reflect checks and balances? Let's just look at it. A bicameral legislature. We are talking about two houses, the Rajya Sabha and the Lok Sabha in case of the parliament, and this provides internal checks and balances to the parliament, to the legislature itself. It's a very internal tool to the legislature, but not concerned with the holistic picture of all organs. So this is something that we can rule out. The second option says separation of powers with institutions like the Election Commission. Absolutely correct. This is our correct answer. So when we are talking about checks and balances, we are actually talking about separation of powers, no one organ of the state becoming all powerful, and of course there are constitutional bodies like UPSC, let's say the CAG, the EC, Election Commission, that aid in the separation of powers. So this happens to be our correct answer. Universal suffrage again is not really relevant to checks and balances. It's more relevant to the concept of democracy, and the federal division of powers again refers to the vertical division of powers between the union and the states, but it does not deal with the organs of the government. So here we can arrive at our correct answer, which happens to be option B. Question 1 says, which of the following best explains the term Bill of Rights? So what exactly is meant by Bill of Rights? In very simple terms, if we talk about Bill of Rights, we usually mean that in a democracy, all the rights of the citizens must be acknowledged by the government. All right. So in a democracy, there must be certain rights for citizens, and these rights should also be acknowledged by the government. So it's not sufficient to simply have rights, they should also be accepted and agreed to by the government. How does this happen? To ensure that this happens, these rights are listed in the Constitution. So the rights are listed in Constitution itself. So when these rights are listed in the Constitution, this practice ensures that these rights are not violated by either a private person or a private organization or any organ of the state. This listing of rights is known as, or these rights are known as, Bill of Rights. All right. So let's just look at the option to arrive at a correct answer. Option A says a parliamentary enactment guaranteeing fundamental duties. So no, first of all, it's not parliamentary enactment. Second of all, we are talking about rights, and even though they are correlated with duties, this is not what we are looking at. A list of rights mentioned and protected by the Constitution. Absolutely correct. Like we just said, we have to ensure that these rights that the citizens possess should not be violated either by the government or any of its organs, or by a private person or an organization. Option C says an executive order protecting civil liberties. No, of course not. We are talking about rights that are being protected by the Constitution itself. And D, a judicial declaration of citizens' duties. Again, we are not dealing with duties right now. We are dealing with rights that are constitutionally protected. So again, we have option B as our correct answer. Let's move on to question 2. The ideal of welfare state in the Indian Constitution is enshrined in its, and this is a previous year question, and again it has been asked a couple of times in the recent few years, and the answer is fairly simple, it's fairly straightforward. So you can imagine how important reading at least your class 11, class 12 NCERTs are for you, because like I had said in our very first video, that questions are lifted directly from the NCERTs. Lifted sometimes even word by word. Now in this case, we are talking about the idea of a welfare state. What exactly means a welfare state? What is exactly meant by a welfare state? A welfare state is that state where the government actively promotes the welfare of the people or people's, citizens' well-being. So this is what is meant by a welfare state. Basically, the government is going beyond doing the bare minimum. What is doing the bare minimum? It's maintaining law and order. So any state where the government goes beyond maintaining law and order and actively promotes the welfare of its people is basically called the concept of the welfare state. This ideal basically ensures that there is justice for citizens. What kind of justice? Political, economic and social. All three kind of justice are maintained for the citizens. That is the whole idea of a welfare state. Now in our constitution, this ideal of the welfare state is reflected in part 4 of the constitution, which is the DPSP or the Directive Principles of State Policy, contained within articles 36 to 51. All right. The good thing about these DPSPs is that they guide the governance of a country fundamentally. However, they are not justiciable. DPSPs are not justiciable, which means they cannot be enforced in or by any courts. All right. So you cannot hold the government liable for not implementing DPSPs, but at the same time, they are fundamental to governing the country. So let's look at the options. The first option is preamble. Now this is where you could find it a tad bit confusing. Why? Because preamble also talks about justice, economic, social and political. All right. However, preamble is only indicating. Preamble is only indicating the vision that our founding forefathers have or had at that time for our nation, for our newly independent nation. This reflects only the vision. The principal guarantees, or let's say the fundamental principles that actually make sure that the welfare state is established is discussed in detail in part 4 of the Constitution amidst the Directive Principles of State Policies. So while this appears like a very tempting option, we'll have to rule it out. B, DPSP, this is the correct answer, Directive Principles of State Policy. C, fundamental rights. See again, fundamental rights is talking about individual rights and not collective welfare. Please notice, you may be again thinking that fundamental rights is also pointing to welfare of some sort. But we should notice that it refers to individual rights, whereas that your DPSP is referred to collective welfare or principles of collective welfare. And finally, D is 7th schedule. Here you can see that the 7th schedule talks about the division of powers, the 3 lists. So it's not, and of course it does contain subjects like education, health, right? But it does not really embody the idea of a welfare state. So we have option B here as the correct answer. Question 3. Which of the following statements correctly describes preventive detention in India? Now, in order to understand what preventive detention is, let's just take a look. So, detention in India is of 2 types. Detention can be understood as punitive or preventive. Punitive and preventive. Both these types have been referred to in Article 22 of the Indian Constitution. Before that, Article 20 also talks about protection in respect to conviction for offences, and Article 21 talks about right to life and personal liberty. Now, why I'm mentioning these 2 articles is because this article follows from there and sometimes even is contrary to the provisions contained in this Article 21, which is right to life and personal liberty. Now, let's understand what is meant by punitive. Punitive detention simply means that you are arrested for an offense that you have committed. You are arrested for an offense that has been committed by you. Okay? So, there is already an offense that was committed. However, in this case, you also get certain rights. Alright? What is the article called? The Article 22 talks about protection against arrest and detention in certain cases. Article 22 talks about protection against arrest and detention in certain cases, and we are talking about 2 types of detention, punitive as well as preventive. So when we talk about punitive, we are talking about punishment, detention as a punishment, as you can derive from the word punitive, all right? Offense that has already been committed. If you're arrested for that, then that becomes a punitive measure, a punishment, all right? But there comes certain protections, certain rights with this provision. So the earlier clauses, at least 1, 2, 3 of Article 22 talk about the rights that a person has when arrested. First right is that they should be informed about the grounds of their arrest, all right? Even if you check the news recently, you see that this case has risen up where the government did not bother to inform the accused or the arrested person's wife about the grounds of that person's arrest, right? This is a fundamental right. One has to be informed about the grounds of their arrest, why they are being arrested. Second, they have the right to consult a lawyer of their choice, a legal practitioner of their choice. They have that freedom to consult a lawyer, all right? The third right that comes is that the person has to be presented before a magistrate within 24 hours of arrest. So within 1 day of your arrest, you have to be presented before the magistrate. And finally, you cannot be detained. You cannot be detained without the permission of the magistrate. That is the fourth right that you can actually invoke while you are in punitive detention. However, all these rights do not apply in two cases. What are the two cases? These rights do not apply when we are dealing with enemy aliens, all right? Foreigners that belong to countries with which India has had wars in the past, all right? Enemies of India. These do not apply to enemy aliens, and these do not apply to people who are detained under preventive detention, all right? So people who are detained under this clause cannot avail these four rights. What is meant by preventive detention? Preventive detention simply means that you arrest a person not because that person has committed a crime or an offense, but because you speculate that there is a likelihood that that person may commit a crime or an offense. All right. So this is what we mean by preventive detention. Means that no crime has been committed, but only on the suspicion or mere anticipation that the accused may commit a crime or an offense that can challenge national security, law and order, the person is detained. All right. So this is what preventive detention means. Let's go back to our question. 1. It allows detention without formal charge or trial. This is accurate. There is no formal charge, there is no trial, because no crime or offense has been committed in the very first place. Second, the period of preventive detention cannot exceed 3 months without advisory board approval. Now, this is another important caveat while we are discussing preventive detention. Of course, you can arrest the person and detain that person on grounds that he is a threat or she is a threat to national security or public law and order, law and public order. But for how long would you detain this person? So it is basically mentioned that you cannot detain a person on grounds of preventive detention for over 3 months. And if you want to exceed this period, you will have to get an approval from an advisory board. All right. So this is absolutely accurate. Third, it can be invoked only during national emergency. Now, as before, I have told you to watch out for the word only. Any term that is over emphatic or that talks about exclusivity. All right. Only. All right. All, completely. Something that is extremely emphatic or very exclusive. So one red flag in this statement is this. Now, while studying about it, we did not mention that this will happen only in the case of national emergency. It can happen whenever. Preventive detention laws can take place anytime and not necessarily during national emergency. So this we can rule out. Hence, we know that statements 1 and 2 are correct, which gives us option A as the correct answer. Question 4 says Article 20 of the Constitution provides which of the following protections? Now let's try and recall what Article 20 is. Article 20 is basically protection in respect of conviction for offences. So this is your Article 20, protection in respect of conviction for offences. Now this contains 3 categories. One is that you cannot be convicted for an offence from a back date, which means you cannot be convicted for ex post facto laws. Alright. So if you committed a crime in 2024, any law that criminalizes that act in 2025 will not hold you guilty of that crime, which means you cannot be punished from a back date. Alright. Also, you cannot be punished more than is prescribed in the law. The second protection is that you cannot be forced to incriminate yourself. You cannot be forced to plead guilty against yourself. You cannot be forced to say that you are guilty of such as such offense. That cannot be done. You cannot also be forced to give your signatures or any testimony against yourself. All right. You cannot be forced to become a witness against yourself. So that is one other protection that has been provided by Article 20. And finally, there is something called double jeopardy, which means you cannot be prosecuted or punished for the same offense twice. All right. So now with this information in mind, let's look at the options. 1. Protection against double punishment. Absolutely. I talked about double jeopardy just now. And this is in fact accurate. Double jeopardy. All right. So yes, it does provide a protection against being punished twice. You cannot be punished for the same offense twice. So if you committed an offense and you were fined for it, you cannot be jailed again for it. All right. Second is protection against retrospective criminal laws. Yes. Ex post facto laws or laws in the past. Something you cannot just begin a law saying that this act will henceforth be punishable from 2024, even though we are living in 2025. All right. So this cannot happen. So again, the protection is provided. Third, protection against self-incrimination. Of course, you do not have to. You cannot be forced to plead guilty, or you cannot be forced to testify as a witness against yourself. So this again is a protection that is guaranteed under Article 20 of the Indian Constitution. The article says protection in respect of conviction for offences. All right. So all three statements are correct. Therefore, option D is our correct answer. Let's move on to question 5. Which of the following are envisaged by the right against exploitation in the Constitution of India? Now, right against exploitation basically refers to Articles 23 and 24. And this is again a PYQ. Now, looking at the options itself, you'll figure how simple the question UPSC has asked. It's not a very difficult question. If you've read your fundamental rights, even the sequence of them, then you know it's going to be a cakewalk for you because it's not even confusing. All right. So when we are talking about Articles 23 and 24, we are talking about right against exploitation. When we are talking about right against exploitation, we know that Article 23 deals with prohibition of traffic in human beings and forced labor, begar, right? And Article 24 talks about prohibition of employment of children in factories and mines, which prohibits children under 14 years of age to be employed in dangerous occupations. All right. So these two, of course, we know are the correct answer. The other two, abolition of untouchability, Article 17, under right to equality, and protection of the interests of minorities is again a matter of Article 29 under educational and cultural rights. So we have statements 1 and 4, the two rights, and option C therefore is our correct answer, and this is your practice question for the day. Please take a look at it. You may please send me your answers in the comment section. Today's session was fairly intense. If you enjoyed today's session and would like you to continue these videos to be on the channel, kindly press the like, share and subscribe button, and thanks for watching.
For more informative content, like share and subscribe, and do not forget to press the bell icon to get the notifications.